Hello friends, welcome to Talent Hub Training Institute FinSolve segment. How are you? Hope all of you are safe and at your home. We know that in this present scenario, many of you want to start your own business. But then you find lots of legal challenges and lots of option is also there. So taking decision is a bit tough. I know. Here we are trying to solve this problem by simple understanding of business-oriented legal compliance. For this, we introduce a video session with different videos. And overall above, from here you can take a certification by completing this session just via online exam. Every video description will provide the link, but we request to all of our viewers first go through all the 8 video sessions, then avail the test for better result, because we will only provide the certification for those who will secure the 60% of marks. So let's start our session.
Today, let us talk about key contracts and the legal documents for business. In business, contracts are important because they outline expectations for both parties. They protect both parties if those expectations aren't met. In this chapter, we will discuss the different types of contracts and legal documents required to run a business effectively and legally. Now let us start with understanding why does a business entity need legal contracts and agreements. Basically, they provide a strong backbone to the company and establish the rights and limitations. They are crucial during the time of disputes within the company or beyond. The contracts act as a proof that the parties involved agreed upon certain rules and regulations and they must abide by them or face consequences. They are categorized in two parts: internal contracts. They are basically the contracts which govern and manages the internal operations and relations of the company and its members. External contracts. They govern and manage third party and company operations and relations. They help in defining rights, duties and responsibilities, limitations, methods of dispute resolution. Now let us understand each one in brief. Many startups these days have co-founders or early investors who share equity in the venture. It is important to have some clarity beforehand about the roles, responsibilities, rights and obligations. This will help to avoid any bitternesses later. Following are some contracts and agreements that are imminent for business owners and the shareholders. Term sheet. Basically a non-binding agreement. It lays down all the terms and conditions agreed or disagreed upon by the parties involved regarding the deal. The final contract is drafted according to this term sheet. Founders Agreement. This outlines the important aspects of founder relations and establishes an agreement about how the founders plan to divide the roles and responsibilities, equity ownership and IP ownership amongst the founding team. Having a clear agreement amongst the founders safeguards the future viability of the enterprise and it is easier to raise money. Shareholders Agreement. This agreement governs shareholders' rights and obligations, transfer of shares, how the company is going to be run, and how important decisions are to be finalized. It clears the authority and standing of each shareholder and brings clarity. Share Purchase Agreement. An agreement between the two parties in which the seller agrees to sell the stated number of shares to the buyer at a particular price. This agreement is important so that no one backs out from the agreed price or amount of shares to be bought or sold. Employees these days are considered the most important assets. As you hire your key employees, it is important to set certain understandings. You need to be very clear on these, and let's look at some contracts and documents which will help to transparently define the employer-employee relationship. Employment Agreement. An employment contract is necessary when hiring any employee or consultant, whether part-time or permanent. It is an all-inclusive record on paper that establishes the duties, responsibilities, rules and formalities that the employee must abide by. Along with that, it also states the employee rights, salary and leave rules. Non-disclosure. It puts a restriction on disclosure of any confidential information. Non-compete. That prohibits the employee from entering into competition with the employer. Ownership of inventions. An agreement stating that anything invented at work or during a set period of time after termination becomes the employer's invention, not the employee's own invention. Termination clause. This defines the rules governing the employment termination. The company HR handbook. By laws and policies, the HR book is a compilation of company bylaws and policies and all aspects of internal relations of the members. It includes the rules regarding working hours, code of conduct, leave policy, interpersonal relationships, performance management and appraisal, grievance redressal, intellectual property, etc. Every company must have a well-structured company policy. This defines strategy for developing, communicating and enforcing a set of practices that reflect the company's standards of acceptable behavior and is in sync with the company objectives and work ethics. Let's discuss the major clauses that this one must include. Company policies, terms of use. Term of use is extremely important for businesses that have a website, as they limit your liability if there are errors in your own content or information contained in any hyperlinks from your site. It outlines do's and don'ts for visitors to the website. Privacy policies. Many online businesses gather data and information from the visitors and customers that visit the website. The privacy policy describes how this information will be used and not used. It is a mandatory legal requirement. Company bylaws. Bylaws establish how the company governs itself. It defines important details about the business structure, governance issues, and individual roles of all parties involved with the business. Bylaws are especially useful if disputes arise regarding voting and the specific roles of employees within the business. The rise of outsourcing and strategic business partnerships has increased the use of third parties. Thus, it is important to have defined contracts and agreements that govern the company and the third party relationships and transactions. Here are some essential agreements that help in maintaining secure and smooth business relations with such parties. Vendor agreement. This is a comprehensive agreement covering various aspects of a relationship with the vendor. It includes quality of goods supplied, duration of contract, mode of payment, etc. NDA. Having an NDA between the company and a third party is vital, as the company shares its crucial business information with them. From exclusive business ideas to business strategy, the company's internal information is shared outside, and hence keeping this data confidential is a must. Franchise agreement. This is the agreement wherein the franchisor agrees to lend the trade name or business system to another person or entity, the franchisee. The agreement here will usually include the terms and conditions agreed upon between the parties, remuneration for the franchisee, conditions and term of use of the brand name, disciplinary provisions. Master service agreement. This contains all the rules and regulations that govern transactions between the client and service provider. It covers rules regarding confidentiality, delivery requirements, dispute resolution, geographic locations that the parties will operate and manage, intellectual property rights, liability, payment terms, jurisdiction, and work standards. IPR license and assignment agreement. This facilitates the assignment and licensing of IP. This includes clauses like what is IP that is assigned or given on license, right of the assigner or assignee, licensor or licensee, consideration amount with the period from which the assignment or licenses are made. Leases and agreement. A business lease or rent agreement for office or retail space is often one of the most significant contracts for a business. It includes clauses that define duration of tenancy, rental amount, notice period or renewal term, maintenance, and many more. These were some of the most common and important contracts and agreements that any business must incorporate and abide according to their applicability. Hence, to conclude, we can say that before any business is incorporated, one must look deep into it to ensure that one has covered all the legal requirements regarding contracts and agreements to carry out the business legally. Otherwise, they may face many issues and disputes when it comes to internal or external operations. Thus, it is always better to have a legally binding document that establishes all the rules and regulations and brings clarity to all the parties involved. We hope this was informative for you and look forward to seeing you again. Thank you.